Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We do this community conference call every other Thursday, most times, unless a Thursday falls on a federal holiday. In that case, the schedule is shifted. I just need to test real quickly, make sure that you guys can hear me all right. So just one moment.
The conference is now in conversation mode.
Can you all hear me okay, guys?
Yes.
Okay, excellent.
The conference is now in presentation mode.
Some of you have already attended this call, so you know the routine. But for those who are here for the first time, I am going to go over the questions that I have marked as frequently asked questions first. If you have a question that follows on that what I have discussed, feel free to ask it. I will give you an opportunity to do so. But no new questions. If we have time remaining at the end of the call, we'll take up new questions. For now, we'll be dealing only with posted questions and questions that follow from that. I forgot to mention the date. Today is December 9th, 2021. First question, frequently asked question is, and this is an interesting one. It actually raises several issues that people should generally be aware of when they have filed the 485. The question is, working for two employers on W-2 using the green card employment authorization. What are the consequences? How does it work? So the first question that they asked me was, will USCIS question why I am working with two employers, will it impact the pending I-485? And the answer to that question depends upon the very basis of a 485. If 485 is filed indicating to the government that there is a job presently in hand or sometime in the future that I, the employee, intend to take up either now or when my green card is approved. So the essence of a 485 is intention to join the employer. However, once the I-140 is approved and 485 has been pending 180 days, that intention can be changed. What does that mean? So let's say I got my green card started with IBM, filed my 485, and the 485 and the I-140 stayed pending for 170 days. After 170 days, my I-140 gets approved. That means 10 days later, my I-485 would have been pending 180 days. At this point, I can change jobs to a same or similar position anywhere in the country. And there is sufficient policy information to suggest, in fact expressly says so, that I can even start my own business. Although I'm a little cautious about that part, and I won't normally do it because there are certain areas that the policy has left kind of blank, and I would rather not gamble with them. So technically, once 180 days are over, you can take up a same or similar job anywhere. However, when you filed the 485, it was your intention to either continue working or in the future work for IBM, the employer, who started your green card. Now, when you have two jobs simultaneously, it could be questioned, what exactly is your intention? Remember, after 180 days, the intention is irrelevant. But what if it is before 180 days? Can intention be questioned? Sure. But in this case, the situation is relatively easy. Why? Because here we have a case where one of the jobs is just a short-term contract or a project, and they are paying you on W-2 instead of a 1099. That's perfectly okay. I don't see any problem with that. So the essence is, if you have a job that you intend to do permanently or at least on a long-term basis, that's your intention. It can change. But your current intention is to continue there. The fact that you're also doing a second, third, or a fourth job, that's your prerogative. Nobody can stop you from doing it. So that part does not bother me. Next question is, instead of 2 W-2s, can I have the second job on 1099? Sure, absolutely. I'm very fond of telling a story. One of our clients actually had 3 full-time jobs at the same time. And the reason he could do that was because he was a senior database administrator. He was there for troubleshooting. He didn't actually have to work at 3 locations. He just had to be available on call. So if you can do 3 jobs, by all means do so. The basic idea is the one job that is getting you your green card, you have the intention to either continue or to join it once you have your green card. Okay, so that's the second question you had. Let's see the next question. During the green card interview or in RFE, if they ask me to provide W-2, can I produce only the primary employer's W-2? Well, first of all, you are not doing anything illegal. Why would you want to hide it? I never would let you. If you were working with us, when it is legal, why would you want to hide it? And if it is illegal, do something else to make it legal. Don't try to hide it. The second part of the question is, so I would produce both W-2s. And the last question is, if interviewer asks, how come you have 2 W-2s? How to answer the question in a more convincing way? Look, you don't have to be a salesman. You just have to tell the truth. Whenever you go for a 485 interview, you are put under penalty of perjury. You must tell the truth. If you tell a lie and government wants to make an issue of it, not only can they bar you from coming into the United States forever, they can prosecute you. It's a felony to lie under oath, punishable by 5 years in prison, up to 5 years. So therefore, the bottom line is, you can have multiple jobs while you're on EAD. I don't see any problem with that. As long as your intention towards one remains clear, and once the 180 days have passed, as I stated, you can then even change jobs or have multiple jobs and potentially even work for yourself. Star 5, if you have a follow-up question. No new questions at this point, please. If you have a follow-up questions on what I have just discussed, press star 5 on your phone. Okay. Area code 612. Where are you calling from?
I'm calling from Chicago.
Yes.
I was the one who posted this question.
Yes, sir.
Thanks for answering that.
Absolutely.
So you said, I can work for a self-employment. So you mean to say I can start my own company and do that. So that is one option. Or the derivative can start the company and she can run the business, right?
What I would want you to do is to have a one-on-one consultation either with us or with your own lawyers. Make sure you understand the implications. That's usually the last ditch option I exercise. I try to stay away from this option because I see several loose ends. Although we've had cases where this option of having your own business was indeed exercised and it worked out well. But there are indicators that must exist. Is this a real job? Can somebody fire you? Is the employer actually doing business? Things like that. So I would be careful with that option and exercise it only if I don't have any other choice.
Okay, but the derivative can start the business and she can run the business, right?
Derivative definitely, because it's funny. The derivative has more rights than you do. In your case, your wife can run a company, work, not work, do something totally different from her education. If she has a degree in medicine, she can be doing technology, or she has a degree in technology. She could be running a gas station. Anything she wants to do, no problem.
Yeah, she can start a C corporation as well as a LLC, whatever may be.
Yeah, that's a business decision. That's totally beyond our discussion today. But as far as having her own business, any kind of business is concerned, yes, she can. And as to how that would be organized, that's a different discussion for business lawyers or CPAs.
Okay, sir. Last question. But she can run her own payroll in her own company?
Of course. Of course. Many of the people in this country are self-employed, and many of them have their own companies for whom they work as employees and get paid a salary, like I do for our firm.
Okay, sir. Thank
Okay.
you. That's all I need.
Good luck.
Thank you.
There's another follow-up question. I hope it's a follow-up question and not a new question. Area code 424. 424, what is your follow-up question?
Good afternoon, sir. This is a follow-up question on Mr. Chicago's query here. I'm in the same situation with a pending I-485. Is it possible for me to work remotely for my current U.S. company while waiting for my 485 approval
Absolutely.
outside of the country?
Absolutely. Absolutely. So you see,
Wow. So,
what is the basic criterion we are worried about? We are only worried about one thing. Do you have the good faith intention to work at this job? Okay. And the fact that in the interim you went away to Burma, Bhutan, Switzerland, anywhere your heart desires, should not matter as long as there's a thread of continuity of your intention. When you are actually working for that job, even though from a different premises, I think that's very good evidence of your continuity.
I see. So when I receive the green card, do I have to return to the country immediately, or
You
can I
should.
continue staying
You
on?
you should. You should, because until you land in the United States with the green card and join the employer, your green card is not complete. So you should come as quickly as you can.
I see.
Normally, if you are from India, different countries may have different time periods. If you are from India, once your immigrant visa is stamped, you have 6 months to travel into the United States. You should definitely come within that time.
Mm,
Okay?
got it. I see. Okay, and so for me, my concern is I was an F1 OPT STEM, and I got a perm labor certification in the U.S.
hmm
And would that affect anything, or?
It doesn't change anything. Okay?
Oh wow, that's really good to hear.
You're welcome.
Thank you. Last question, sir. So when I receive my green card, how soon can I leave my current company while minimizing risk later on?
This is what I want you to do.
I
Go
do the same thing
to
where
go to immigration.com and go to the frequently asked questions on our website. This issue has been discussed no less than 17, 18 times in great detail. Read through that or listen to the audio recordings, and if still not clear, come back here Thursday after the next one. Okay?
Thank you, sir.
You're
Thank you so much
welcome.
for your time.
Good luck. Okay. Yes, this is a relatively easy discussion, but it's a long one. So I can't repeat that. Let's go on to the next frequently asked question. This is a very sad situation and very annoying in some ways. So I'll read through the question, but from what I know of these scenarios, so this is what happens. I'm a STEM student. Okay. STEM OPT extension is going on. My employer files my H1b. Now, the moment they file an H1b with the change of status, the DSO in my school will immediately proceed to invalidate or close down my service account, because now I'm going to go on to H1b. Okay. So according to them, once it's approved, the H1b change of status is approved, service is done. No more service. But if before the approval occurs, my H1b is withdrawn, at least the request is made, and then it is mistakenly approved, my DSO should not revoke my service. So the scenario is H1b was filed with a change of status request. Then employer, before it was approved, sent in a request for withdrawal, which means you should remain in STEM OPT status. You are not in any other status. But USCIS, being as slow as they are, instead of allowing the withdrawal of the H1b approves the H1b. Now I have lost my OPT. My H1b is gone. There is a request for withdrawal pending. Once that's acted upon, my H1b will be gone. So from being in F1 OPT status or even H1b status, I go to being in neither one of them. That is very annoying. And it's also very sad. So this is what is going on here. Let's just make sure. I'm helpless. Initial OPT expires November 30th. So it expired, not expires. My STEM extension has been denied based upon an approved H1B which is pending for withdrawal. Right, that's the situation. Yeah, I kind of remember. So your current employer's attorney raised the ombudsman's request. You've taken the Ohio Senator's help, but no response. So now I'm running out of time. My previous employer's attorney is not willing to join call with the Tier 2 officer. They are not helping at all. My current employer is reapplying for my STEM OPT extension. Good. I think you've done everything that you can. There is not much I can tell you, Akashji. I think you pretty much done everything you can. You have contacted the senator's office. Your lawyers have opened an ombudsman's request. You are refiling the STEM OPT with considerable amount of evidence saying, reopen this case, give it to us. There are a couple of things that I would suggest you do. You can go talk to your DSO, okay? Explain to them the situation and have them talk with the SEVIP people and see if the SEVIP people will allow your SEVIS reinstatement based upon evidence of withdrawal or request for withdrawal. They may not be able to, but it doesn't hurt to try. That's one thing you can do. And the second thing you can do is you can try reaching the Tier 2 officer with your employer on the phone. It doesn't have to be your lawyer. You can get your employer, somebody from your employer side, your manager, your HR people, somebody from the office on the phone. Once you get to a Tier 2 officer, talk to them, explain to them the situation, ask what they suggest. Those two are the things that you can try. *5 if you have a follow-up question. *5. Okay, let's go on to the next frequently asked question. Okay, this one also comes up quite frequently, which is correcting names on passports, visas, other documents. And this is the way I approach this. I find it the most convenient to do a name change through the courts in the United States. You're already here. Doing a name change through the court system is a very easy process. You don't even need a lawyer for that, at least as far as I know. Any states that I have recommended to people to go do a name change through the court system, they've not hired a lawyer. Maybe there are states where you would need, but I don't think so. So you begin by calling the courts and saying, I want to do a name change. What are the formalities? Typically, they'll refer you to online information or email you the information. So you get the name change. Once the judge orders the formal name change, now you have something in writing from the court. Okay. As far as the US documents are concerned, from there on, it is just a matter of sending the documents to the right authorities. For the green card, for the Social Security Administration, all the various agencies involved, because you have a decree, a court order, they should be able to change your name quite easily. What happens to your passport? Now that's something before you do a name change. See if the consulate that you are from, the country you are from, has some information or can give you some information about what they would accept as sufficient evidence of a legal name change to give you a new passport under the new name. So as far as that fly in the ointment is removed, you are good to go. That's what I would recommend. So let's just take a quick look at the question. I can do an I-90, but that only gets you your green card, you see. When the name correction is going on, any issue traveling? I don't think so, because as long as you can prove you are the same person, which you can, You will be delayed probably because they put you in secondary inspection when you return, but it's not illegal to travel while you're trying to do a name change as far as I can think of. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go to the next frequently asked question. Oh, there is a question on this. All right. Area code 647. 647, where are you calling from?
I'm calling from Canada. I have follow-up question regarding this. My organization submitted my USCIS petition for I-129 and they missed out my previous name. Do you think that would cause an issue because my graduation mark sheet and all are related to my previous name?
A little bit of a hiccup. You'll get probably a request for evidence you can explain. But these name issues are not deadly issues. They are merely bothersome. Okay?
Okay. Thank you.
You're welcome. Good luck. Okay, let's go on to the next frequently asked question. It looks like, oh, there's another one. Options to remain in status, F1 visa expired, H1b approved for consular processing, but not stamped. Now, this is another important point for everybody to understand. There is a difference between immediate change of status and deferred change of status. What is immediate change of status? I am on F1, that's my status. I apply for H1b. I request that when you approve my H1b, Mr. USCIS also give me H1b status. So that's an immediate change of status. Okay. Sometimes it doesn't kick in immediately. For example, if you are going through the quota and you received your H1b approval with a change of status approval in June, but it will only kick in on October 1st. That's not a problem. That's a different issue. But it's important to make a distinction between a change of status and consular processing for changing your status. Technically, that's not what it's called, but let's call it that for now, for the sake of convenience. So when you have asked for a deferred change of status, which is going through the consulate, your current status is not then disturbed. So for instance, in this case, what happened was, son got his H1b approved in for consular processing this year, which is his first year of OPT. His visa expired, F1 visa expired in June. He is unable to travel to India because no slots for H1b stamping. So 2 questions. Number 1, is there a time limit for getting the approved H1b visa stamped? No. If for some reason he's unable to travel next year as well, can he extend his STEM OPT? Yes. Because remember, he has deferred his H1b change of status by requesting consular processing, which means Mr. USCIS, approve my H1b, but I will trigger it only when I go and apply for my visa in the consulate. Until then, I'm still on F1. I can go from F1 OPT to STEM OPT, no issue at all. Okay. Star 5, if you have a follow-up question on this, press star 5 on your phone. Area code 669. 669, where are you calling from?
Hi, sir. I'm calling from New York.
Yes,
I
sir.
have a follow-up question on that. So can I travel to India and come back before my effective H1B date?
So let's take that hypothetical. So the idea is, I filed for the lottery. I got my H1B approval in June or July. It doesn't kick in till October 1st, but I am on my student status. Can I travel using my student visa? Is that the question?
Yep.
To the best of my knowledge and remembrance, yes, you can. Where can you double check this? There is actually a frequently asked questions document that was put out by, I believe it was, I don't know why I want to say ICE. because I think they were answering these questions with reference to student visa. So ICE has, I believe so, said that under these circumstances where H1 has not yet been triggered but has been approved, you can travel and come back using F1 visa. On October 1st, you will be automatically on H1b if your change of status was previously approved. Okay?
Okay, sir. And one more question. So right now my H1 application is in pending state, and my employer said they have requested to be activated in March. So is it possible like I can travel before March?
When you have a change of status pending, you cannot travel. If you do travel, your H1 will be approved, but the change of status is abandoned. That means you would either have to apply for change of status again after you come back, which is like filing the H1B again, or go for consular processing after you return. So possible, but uncomfortable.
I see.
Okay.
Thank you, sir.
You're welcome. Good luck. Okay. So next, I don't think we have any more frequently asked questions. I'm losing my voice. Going back to the non-frequently asked questions. So this is about a TN visa for a Canadian employee currently on J1. Does the J1 have home residency requirement? Are you here, the one who posted this question? Press *5 if you're here. Excellent. Area code 613. Hi, area code 613. Are you calling from Canada?
I am, yeah.
Okay. So first of all, do you know if the J1 has a home residency requirement, the 2-year rule? I don't think it would.
It doesn't, no.
It does not. Okay, good. Now, I see absolutely no advantage in doing a pre-processing. Okay. Absolutely zero advantage. The pre-approval does not make any sense to me in this case, even though the USCIS will allow you to pre-process a case 6 months ahead of time. This has not been documented anywhere as far as I know. This is just a matter of policy as we know it. Okay? But I don't see any point in it. It is so much easier to just go to the border and enter through the port of entry. Any particular reason why you are thinking of getting a pre-approval?
I think that we'd just like to know whether or not it's feasible.
Any
technical lawyer.
Any competent lawyer can look at the case and give you an opinion. These are not difficult cases to decide. Only when you have cases that are sitting at the cusp, for example, a business consultant. Okay, these are cases that are difficult to decide. What is the degree implicated here? What degree do you have?
Undergrad in health sciences, master's in global health.
In global health. And what kind of job is being offered?
It's a technical writing position at a health nonprofit.
Technical writing position. I don't remember what the rules for that are. I'll have to look at the schedule to the NAFTA. Well, now it is USMCA, whatever that is called. I'll have to look at that, but have your lawyers assess it. It's not rocket science. They can give you very easily the chances of approval. But also remember, just because you have a pre-approved H1 TN visa, TN status, it does not mean you are going to make it through the border without any incident. They can still question whatever has been decided. Okay. So if the purpose of filing this is to have a modicum of certainty, I think that can be perhaps almost as equally efficiently and reliably assessed by a lawyer, rather than having to do a pre-process of the TN. That's what I would advise. But can you do it? Sure. Is it beneficial? Probably not. Do you have to wait until the J1 is over? Because it doesn't have a home residency requirement, you do not.
Okay, perfect.
Okay. Anything else?
I was also wondering the third question on the post about the
Are there any other
that we need to
materials?
submit aside from the I-129.
What you should do is the Customs and Border Protection puts out a checklist for CBP approval. That's a good for a TN approval. That's a good checklist to rely upon. It'll tell you need to prove your degree, you need to prove the existence of this job. If there's a contract, you should provide a copy of the contract. So there's a checklist. You should be able to find it online. Okay.
Okay. Thank you so much.
You're welcome. Good luck. Okay, so the next question is, this is odd, Arjun. Approved N470 CBP warrant or re-entry and filing F2A for spouse. The problem is, if you have been gone past your re-entry permit, of course you're going to have problems. So you're currently in India working for a subsidiary of a US-based company. N470 is approved. I had approved I-131 re-entry until June, which is now expired. You traveled and came back in October past your re-entry permit. USCIS updated me they have reused the biometrics. Okay, that's fine. When you came the last time, the immigration officer gave you a warning that the green card can be taken away. Sure. Basically a green card can be maintained only reliably if you actually maintain your permanent home. That doesn't mean just the house. It means you actually live in the United States. You should be worried about it because if you do not return within the life of your re-entry permit, next time you might not be allowed in that simply. They'll allow you in, but then they'll take your green card and you'll have to go through a deportation or exclusion hearing. I want to file family-based green card for my wife. Can I file for her while I'm working in India? And the answer is yes, but we've done this a couple of times where somebody like you was in India, or in this case UK, and they filed for their spouse who was in Africa, or maybe it was the other way around. So the point is, it has been done. It does not appear to be a problem, but when it is time for her to interview for her green card at the consulate, you should be either back in the USA or you should be able to show the consulate that you are actively coming back to the United States. For example, you've rented a place, you've got a job, you are on your way back. So you do need to prove that. That's required for the affidavit of support. You must be domiciled in the United States. Okay? If my wife delivers the baby or babies during the process, can they be added? Yes, they can be. If any child that is born before the interview should be added to the application. The consulate should be able to do it on the fly. And if a child is born after the interview and grant of the immigrant visa, they can still travel on the mother's passport before their second birthday. Nothing else needs to be done. *5, if you have a follow-up question on this, press *5 on your phone. Okay, so this one is from India, I can see that. Hi, good evening. Go ahead, please.
Hello, Rajiv. This is Arjun from India. Thanks for your excellent service.
Of course.
Rajiv, so actually I missed out this going to before the re-entry permit expired because there was a big wave to COVID in India and flights got cancelled.
Right.
And I carried all the relevant documentation from CDC which says you have to do double vaccination. And I showed all my documentation saying that I have got married in India. I'm planning to come back. But even then, the visa officer said you could have come. This is a recommendation, but you can still come. And he also said that since you filed the re-entry permit before, I can understand your intention. So next time, if you come more than a year, I have to put you in front of a immigration judge.
If you have a Arjun,
understand my personal thing.
Arjun, if you have a re-entry permit, you should be okay. But if the re-entry permit has expired, understand what is the Purpose of the reentry permit. Reentry permit is simply an official declaration. Even though I'm gone for a long time, I intend to maintain my green card. It is not more than that. That's all it is. It's a declaration from you. Okay. But if you are not establishing your presence back in the United States and seem to have no intention of doing it, they can still find an objection.
Got it.
Okay.
I have intention. I've been maintaining it for the last 2.5 years.
Yeah.
This time I missed out for the COVID and other reasons.
Right.
So I have actually, when I came back, I had submitted my reentry permit application again. So it's in bit processed, and I don't have to go second time for the biometric.
Yeah, I saw that.
So my intention is, if I once I get it for 2 years, within 2 years, after 2 years, I plan to come back to my US because my company is based in the US.
Then you should be okay.
And then bring my wife as well.
Right.
Yeah.
Then
the
you
only
should
thing is,
be
I'm a little worried because the officer gave a warning, and I'm worried with the new I-131 application will have some problems.
That I can't predict, but
I'm not sure if that
I don't
can
think it does. I don't think it should, but I can't predict how it will play out. That's hard for me to predict. Okay?
Okay, sure, perfect.
Good luck.
And one last thing, considering timelines, now it's end of 2001. I'm planning to stay in India for the next 2 years, maybe until 2003 and 2023 and 2024 beginning. I'm planning to come to US. And my green card expires in 2025 June. So, will 1.5 years good enough to come back?
Yeah,
and apply for renewal of green card?
that is not a big deal. I don't see any problem there.
Okay. Perfect. So
Good
thank you so much.
You're welcome.
And one last thing is, if I change the employer because of the COVID situation, the job scene is not great. If I change the employer to another US-based company,
Yeah, hang on. I do not know the answer to that question. I'll have to look it up.
Okay, thank you.
Yeah, no problem.
Thank you, Rajiv. Thanks for your
No
service.
problem. Good luck. Okay, so the next question, this one we've done before. Can I file I-485 when the priority date is current? Recently, I came back to USA on H1 after 9 years of stay in India. Earlier, I had worked with Company A, who applied my I-140 and got it approved in 2007 under EP3. My priority date is current for more than 3-4 years. Can I apply 485? Company A is ready to provide. Okay, so what I want you to do is, this is actually already covered under our frequently asked questions. We've had a very, very lengthy discussion. I'll give you the short version of it, but you do need to go to the frequently asked questions on immigration.com and look for an answer to this question. Can they file or support my green card even though I'm not working for them? I have my doubts because there are 3 components that are problematic. 1, if you had a permanent job, why did they let you go? Allow you to go? And 2, if you wanted to work with them, why did you leave? And 3, did the job continue to exist for the last 9 years? Or if so, who was doing it? So these are complicated issues that can come up. Talk to your lawyers. Theoretically possible, but practically might be difficult. *5 if you have a follow-up question. Area code 240. I should know 240. Hi, where are you calling from?
Hi, Rajiv. This is Shiva only, calling from Maryland.
Oh, okay. Go ahead, Shiva.
Yeah. A small clarification. The employer who has applied for I-140, I came back with the same employer under H1b, and they are ready to provide the required documentation.
That looks pretty good, but still talk to your lawyers. At least that removes any possibility of any fraud allegations or anything. So if you're still working for them, the maximum that can happen is those other factors that I mentioned. Did you intend with them to work with them permanently? Did they intend to have the job permanently? Who was doing the job while you were gone, etc. Those are not big issues because they only could lead to a denial at the most. But if you were not working for them, it could end up being much more serious. So good. But talk to your lawyers and clear out those issues, okay?
Okay.
Good
Do
luck.
I need to file? Do they need to file 140 again?
No. I-140 once approved is good forever.
Okay.
Okay. Good luck.
Okay. Thank you.
You're welcome.
Thank you.
You're welcome, sir. Next question, H1b stamping and Dropbox. Let's see if I know the answer. My H1b visa stamping in my passport ended December 21st, 2019. I've got 24 months, right? If I have to schedule an appointment before December 24, an appointment in January, is that considered eligible? I think so. Double check this. This should be on the USA Travel Docs website. I believe the law only requires that you apply before the 2 years, not that you get approved before the 2 years. Okay. And that's, I think you are okay as far as I know. *5 if you have a follow-up question. Press *5. All right. So this one is an odd question. H1b payroll rules when moving from one company to parent company. So my company is going through restructuring and making some adjustments. My current company, A, who filed my H1b and green card, they also do my payroll, is no longer going to be generating my payroll. Parent company is going to do it. It can impact your green card and your H1b if the control of your employment has also shifted to the parent company, because that means the employer has changed. So this is a tricky situation which should be discussed with your lawyers. We've had these kind of situations come up many times, and there is no one correct answer. It depends upon the circumstances of the case. The fact that some other company is payrolling you is not by itself relevant. But the most important thing is who's controlling you, who's responsible for your employment. That's the most important thing. And that's not a decision you and I can make. Only your lawyers who are involved with the case and know the corporate situation are able to give you a good decision. Okay? So if the control remains with the sponsoring company, it should not impact your H1, it should not impact your green card. But if it does not, you would have to refile the green card from the ground up, starting with PERM, but you'll carry the same priority date. Okay, and you'll also have to do an H1b amendment. So it's a difficult question for me to answer in the abstract. *5 if you have a follow-up question, press *5. Okay, area code 347. 347, where are you calling from?
Yeah, I'm calling from Virginia.
Yes, sir. Go ahead.
So this is the question I posted. And what I understood is, what you're saying is the company who is going to do my payroll, does that, if that company has the control, then everything has to be redone.
Right, because what happens is,
Okay.
a payroll or who pays is just one of the components of whose employee you are. Okay, the way I see it, the employment has a lot more to do with control than just payrolling. Payroll can be an internal arrangement between a group of companies. So there are many companies who file their taxes together under one umbrella. But that does not make that arrangement any less viable than a regular employer situation. So it all depends what their setup is. Worst case scenario, you'll have to start the green card again and do an H1b amendment. None of them is a big issue in my mind.
Okay. And I did have a discussion with my attorney, and they mentioned the same thing.
Right. Good.
But because there is a cost involved and all of this is happening, my company might not do the transfer because that's a huge cost to them.
Okay.
And they might kind of delay the restructure. Now, on the similar line, I have another follow-up question. It's kind of related to me, is when they filed my green card, I was working at location A, at the company location. I was going in the company in Pennsylvania. Now I live in Virginia, and my current home address is my secondary work location. And if they don't refile or if they use the same green card application, and when the priority date becomes current, do I have to work in Pennsylvania or I can work from Virginia as
Well,
well?
this is a very odd situation. If I were you, I would tell them to redo the green card with the secondary location. But it's actually a lot more complicated than that. Often, when we have a transferable job, we file through the corporate headquarters and indicate on the green card application that this is a transferable job. And that way, even though you can be transferred place to place, because the job is located in the headquarters, we are okay if we file the green card through the headquarters. So it all depends upon how your lawyers planned the application. It all depends upon what the reporting structure is. It depends upon whether you intend to come back to the headquarters or wherever your green card was started from. Too many variables for me to comment in the 3 minutes I have with you. Okay? Talk to your lawyers.
Okay, then just
I gotta go.
Yeah, just the last thing. So, okay. Sorry.
Yeah.
No worries. Thank you. Thank you.
You're
Rajiv.
welcome. Yeah, I have a limited amount of time, guys. I'm trying to cover everyone, at least give you some direction on where you need to go. So this is interfiling from EB3 to EB2. 180 days of 485 crossed. Good. Concurrent EB3 I-140 downgrade approved. Good. Original EB2 I-140 approved for more than 180 days from the approved date. Can we interfile EB3 to EB2 with the filing date current in EB2? I have no idea what you're saying. Can we interfile from EB3 to EB2 with the filing date current in EB2? Can we interfile from EB3 at EB2 at AC21? Is all. I have no idea what you're asking. Are you on the call? Press *5. This is a difficult situation to understand. Let me give you the general directions on how it works. So let's say you filed your 485 under EB2 or even under EB3. Tomorrow you want to move to the other category, you can. But the USCIS has been saying, and I think they are wrong, that you can't interfile back again. So if you go from EB3 to EB2, you had filed the 485 under EB3, now you interfiled under EB2, you can't interfile back to EB3. You have, in my view, you should be able to do it, but government feels no. You can always file a new second 485. Okay. Now, I don't know what you mean by AC21 is all passed, but once the 485 has been, I-140 is approved and 485 has been pending 180 days, you should be okay to change jobs. AC21 should kick in. I think that's what you're asking me, but you're not here, so I don't really know exactly what the intention of your questions was. From what I'm seeing, I think I have answered them. Traveling back to the United States on AP while H1b visa stamping is delayed due to 221G, impact on 485. Yeah, you can travel back using advanced parole and not worry about the administrative processing. The only negative impact possible in my mind is if there is some fraud misrepresentation type problem. If it is just a paperwork issue, it has no impact on your 485. *5, if you have a follow-up question on this, *5. Okay. I think we have answered all the questions. Okay, folks, anybody has any question, please press *5. We've got about 13 minutes. Let me see how many questions I can do. So any question, press *5. Here is one from Pennsylvania. Area code 267, go ahead. Let's do it quickly.
Hello, Rajiv. I have 3 questions for you. One is, I was a student in US and then I've completed my education and then went for the OPT because my course is a STEM course. So then I went for STEM OPT, but somehow I get denial for my STEM OPT.
Okay.
I appealed for the denial and there also I was not successful.
Okay.
So at the end, I have moved back to my country.
Okay.
And that happened in June 2020.
All right.
but I got the visa in January 2017, so I still have the visa till January 2022.
Okay.
Very recently, I got an offer from another professor which is ready to give me a PhD and want me to come to the US for the further education.
Okay.
So while I was filing the DS 160, I have a question which says that has my US visa ever been cancelled or revoked?
No.
So because
No.
I moved.
Look, hang on one second. I can't help you fill forms because then I have to sign the forms. But I can tell you this: that denial of an OPT is not revocation of a visa. Okay.
Okay. Is it a cancellation?
No, it is not. All right.
So, and do I still have that visa?
Now, should you use that visa? That's a very complicated question. That we have to look at your history of stay, which I don't have time to do here. If you were never out of status or violated your I-94, then you are not. You don't have a problem with something called Section 222G. 222G says if you go over your authorized period of stay on the I-94 or you work without authorization, your visa is automatically cancelled. You cannot use it. Okay. So I don't know if you have a 222G problem. You might talk to your corporate lawyers, just ask them if I have a 222G issue. I don't know if you can use that same visa. I doubt it. Okay.
Okay. Yeah.
Good luck.
Another question that I have is, have I ever been unlawfully present?
That I don't
or
know.
overstayed the time?
That's part of the same question. 222G and unlawful presence are very closely related. Same idea. Okay.
Okay. So, I mean, just a quick summary. I left the country.
Ma'am, I'm not gonna be able to do this for you. Sorry. You're gonna have to have a detailed consultation with your lawyers. They have to go through your entire history. I can't do this right now. Good luck.
Okay. And what?
Area code 647.
Hi, thank you, sir. So my question is, I have to be TN entry denial on port of entry. So now they have requested me to show strong ties to family bond when I'm traveling next time. So what is the best way of doing that?
You were coming from Canada?
Yeah, from Canada.
Okay. And you were turned back at the airport or at the border?
Via land. So I was asked to go back to my home country.
To get a visa stamping?
No, I was denied twice, and they asked me to withdraw my application. And next time when I'm traveling, I need to show strong ties to Canada and family.
Okay, hang on. Are you a Canadian immigrant or citizen?
Yeah, I'm Canadian citizen.
Wow, that's very unusual. Extremely unusual. Do you work in Canada?
I left my organization to join the other organization in US. So I am not employed right now, but the documentation which my corporate attorney filed had insufficient information, and they actually put me into an incorrect category. So it was kind of they were not happy with it, and they said you don't fit in into management consultant category.
Oh yeah, management consultant is always a lousy category. So you were trying a TN visa. So yeah, do the TN again. That's all you got to do. Do a proper TN, and this issue of strong ties doesn't become a problem then. Okay.
Okay. So in strong ties, what all documentation I
Ma'am,
need to show them?
I just gave you the answer. Strong ties is not an issue if you're doing a TN. A properly filed TN will take care of it. Okay? Good luck.
Okay. And one last question, sir. Thank you.
I have
and
six
one last
people.
question,
I have 6 people waiting, and I'm trying to get everybody done as quickly as possible. Okay? So I'm going to have to beg excuse. Good luck. Area code 201. Please be mindful, guys. There are other people waiting. Make it quick. 201, you are in New York, right? Or New Jersey?
Hello. New Jersey.
Yes,
Jersey.
sir.
Hello, can you hear me?
I can hear you. Go ahead, please.
Okay. Yes. Hello, Rajiv sir. First of all, thank you so much for the service.
You're welcome, sir.
So I just have two short questions.
Okay.
So my first question is, can a student on day one CPT apply or get a Canadian student visa approved while he's on day one CPT?
You have emailed me, I think. I remember this question.
Yes, today morning.
Good. So I can answer here. Then I'll ignore your email. I haven't gotten to all my emails yet. Okay. So day one CPT, can they apply for a visa for Canada?
Yes.
What kind of visa? Tourist visa?
Student visa.
A student visa. So look, can you apply? That's from the American side, we have no problem. Go for it. On the Canadian side, I don't know, but American side, sure.
Okay, so I just want to know, because it's like when the Canadian immigration lawyers or immigration team will be reviewing my application, will there be any issue? Because
I don't know Canadian law. I only practice on the US side. No idea what they will say. But it's perfectly okay for the on the American side. Yeah. Second question.
Okay, so I can apply at least, and whatever happens.
USA doesn't care. USA has no problem with that. Okay.
Okay. Second question is, if my company is not if I go to a day one CPT and if I get an RFP and if my company is not able to defend that RFP, then
it's not the end of the world. It's not the end of the world. Go to immigration.com, go to my blog, and about 14th or 15th entry is about what happens if the CPT fails. Big deal. Just go and get a visa stamp and come back. So what? Okay.
But I can get an B1 visa or H4 visa, any kind of visa in future, just because.
Yeah, as long as there is no fraud or misrepresentation, merely doing a CPT is not an issue. I don't see why not. Okay. But you should be.
Thank you so much.
Yeah, for example, if you get an H1b approval and the government says we don't accept this CPT, what are they going to make you do? Go and get an H1b visa stamp and come back. Many of our clients have done it. Okay.
Okay. Thank you so much.
You're welcome. Area code 352, where are you calling from?
I'm from Florida.
Yes, sir. Go ahead.
Okay, so I'm a student with a F1 visa, and I have a job on campus, and I'm aware that I cannot work off campus. I just wanted to know, can I make some side money, like donating plasma or something like that? Is it legal?
That's a difficult question to answer. I don't think donating plasma is considered to be employment. I doubt it. But it's so difficult to judge these things because the government has never made it clear. So my guess would be it's probably not employment.
I tried Googling it. Even Google brings out a mixed bag of answers. Most people say it's like a gift or compensation, so it's fine. But some people say it's probably a taxable income. But it's not.
You know what you can do? I just have an idea. You could call IRS, and IRS help desk is pretty good. You can call them and say, don't talk about being student status, just ask them, is this taxable income? If I sell plasma and I get paid for it, is it taxable income? If it is taxable income, they could, because if IRS says no, it is not taxable income, then I think you have a pretty secure way of doing it. Okay.
Yeah, I already asked the Plaza Center and all. They said it's not taxable income.
No,
They
no.
won't be giving me any forms
Talk
or
to the
anything.
IRS help desk. That's what I
Yeah,
would
sure, I'll
suggest.
do.
Okay. Good luck.
Yeah, I'll do that. Thank you so much.
You're welcome.
Thank you.
Bye bye. Area code 314. Where are you calling from?
Hey, hi Rajiv. My name is Ravi. I'm calling from Charlotte.
Yes, sir.
I have a couple of questions. Like I won't take much time.
Good.
So I'm a Canadian citizen. And I'm in this country. My second time I came in 2007. I worked till this year on TN. So I applied my adjustment of status through my wife's green card in last October. So they reached the application date was November 24th, 2020. But like my TN expired in July, and I did not receive my EAP. I'm a Canadian citizen, but my birth country is India.
Right.
So I lost job, I lost license.
Right.
I raised the express request a couple of times. I gone through congressman, senator, everybody. And what are the options? Is it mandamus is the good option?
You have two options. One is opening a case with the USCIS Ombudsman's office, pointing out to them.
I did that.
Yeah, if you already done that, lawsuit is the only option left. It may work, it may not work. Worth a shot. Okay.
Okay. So what are the success rate on this?
I can't discuss that because each case is different, each court is different, each judge is different. Okay.
Okay. So, if you can tell me how much it will cost to...
I don't know. Different lawyers charge different amounts. You need to talk with lawyers in Florida.
Okay. I'm in Charlotte, North Carolina.
Oh, Charlotte, North Carolina. Yeah, you need to talk to a North Carolina lawyer.
So I need to file, is it location based or anybody can file? Like if I reach you on by email?
No, it's very difficult. It's very difficult for us to do it from here. We are not admitted in North Carolina. We can sue in DC, Virginia, but not in North Carolina. Okay.
Okay.
Many lawyers work with local counsel, but you end up paying twice the amount. What is the point of that? Okay. I gotta go, sir.
Okay.
Good luck. Area code 484, Pennsylvania. Go ahead, please. 484.
Oh, hi. I was sorry. My name is Rohan. I'm calling from Pennsylvania. I'm actually having a very quick question regarding presidential proclamation that came out on November 26th about all the restrictions.
Yes.
So what is the status for students, F1 students on STEM OPT? So I'm on STEM OPT and I'm planning to visit India.
Okay, hang on, stop. There is no ban right now coming from India. The only ban is if you've been to one of the 8 or 9 countries in Africa that have been banned. But that's a presence-based ban. It is not a citizenship-based ban. Can India be banned tomorrow or day after tomorrow? Look, it doesn't look like it. The data that's coming in seems to suggest Omicron is not that serious, especially for people who have been vaccinated. So I don't know if this is going to become a problem, but right now, as of today, India has no issues. Okay?
Sounds wonderful.
Good luck.
Thank you so much.
You're welcome. Oh, one more thing that I want to add. All these bans that are coming up are all presence-based bans. So let's say you go to India and somewhere along the line you get hit with the ban, you can just go for 2 weeks to a country that doesn't have a ban, then come to US. Okay?
Okay.
Good luck.
Okay. Sounds good. And if you can discuss more on this maybe later on Yuri's channel, that'll be fantastic.
Actually, I've done it a couple of times. Yesterday I was in a call. We had a much smaller gathering, but we only had 30 minutes. I did discuss it in detail. It should be on my LinkedIn page. Okay?
I mean, I was saying if there are any more developments.
Yeah, if there is something comes up, yes. I will put it on the social media, my Twitter account, Insta, what is it called? Instagram, Facebook, LinkedIn, all of those. Google, everything. So you'll have it on my accounts all immediately as soon as something comes out. Okay? Good luck.
Super. And one quick question. What is
Yeah.
your email address? Sorry.
My email is
What's your email address?
help@immigration.com. Help@immigration.com.
Great.
Okay.
Thank you.
You're welcome. Let's do area code 775. Area code 775. Where are you calling from?
Yeah,
Yeah, go ahead.
I'm calling from California, sir.
Uh-huh.
Yeah, sir, I have a very peculiar situation here.
Okay.
I think I emailed you also, and I'm waiting for a response.
Okay.
I am here on a B1, B2, and my daughter is a U.S. citizen.
Okay.
She just turned 18.
She
And
can't
out of
apply for
country
you,
with
right?
us.
She can't apply until she turns 21.
No, she cannot.
Mhm.
But sir, my only question is, I'm on a B1, B2 here, and she's in 12th grade,
Mhm.
and she's finishing her 12th grade. Once she finishes school, she'll enter college, and that's a good time for her to be on her own. Right now, for me to leave her and go after 6 months is difficult. So
Okay.
if I exit the country with her and try to enter back in a month or 15 days,
They won't let you
will
come
that
back
work?
in.
That's my question.
They won't let you come back in.
No, they won't.
Yeah, very unlikely. What you can try to do is this. I would suggest you get a lawyer, okay, because I don't think it's that easy to do it
Okay.
yourself. But if you look at the Foreign Affairs Manual, which is the standard operating procedures for the State Department for giving visas, the fact that you're accompanying a minor child, well, she's not really minor, but she's close enough. The fact that you're with a young person could be used as a reason to try to extend your tourist status. There is a downside.
Okay.
If you get denied, your visa is also cancelled. But you can reapply for the visa, and I think you have a good case why you overstayed whatever status they gave you. I think overall you should talk to a lawyer, but you might be able to to play it in a way that you'll be able to stay here until she's done. Okay.
Okay.
Good luck.
Okay, sir. We will get in touch with you. Thank you.
Yes,
sir.
ma'am.
Bye-bye.
Bye-bye. Okay, guys, I think I've answered all questions. Did I miss anybody? Press *5 if I missed you. Press *5. Okay, one person I missed, I guess. Area code 513. Area code 513, where are you calling from?
Hello, sir. I'm from Ohio. I think I've been asking you this question repeatedly regarding classic situation I'm in. I'll take a bit of a time. So I'm on in my initial OPT, which expired on November 30 recently. But I had to apply my application before November 30, which I did. Unfortunately, when I applied my application before, it was denied, saying that I was approved, my H1b was approved. But I have sent my withdrawal.
Yeah,
6
hang
months
on one
ago.
second.
And
Hang on one second. You posted this question. I've answered it in detail today. Okay. I'm not going to revisit it.
Sir, but I have
Just wait for the recording. Yeah.
Sir, that's not the question. I mean, I'm sorry to interrupt. I got the withdrawal, but I filed the non-pro-tunc request with my attorney. I'm just I have everything right in place right now. But the only thing is I'm waiting for the withdrawal form from my attorney, acknowledgement letter. The only way the service would open my account is once they get that notice, but USPS doesn't deliver it anytime soon. It's almost 10 days. So 2 questions right now. My service is closed. I sent a OPT recommendation which is out of 60 days. I have filed a non-pro-tunc stating all the evidences. I have took the congressman's help. I have tried the ombudsman help. It's the USCIS error that put me in this situation where I couldn't give the right document they required. So do you think non-pro-tunc request has a success rate? Would they look into
Look,
my...
without knowing the details of what papers have been filed and what case has been made, if you asked my opinion in the abstract, I think you have a very sympathetic case. I think government should accommodate you. Okay. I think that not to accommodate you is extremely unjust because you've done nothing wrong. It's just that if they take forever to act on the withdrawal and approve the damn H1b, which you never wanted in the first place, you shouldn't have to suffer for it. So do you have a good chance? Without knowing the details of the documents submitted in the abstract? Yes, you do. Okay.
So one last question is, so I have filed a paper-based application. With recent online application, there is a way where I can upload unsolicited documents.
Yeah.
My school gave me a recommendation letter. The reason we couldn't provide the I-20, which I did.
Right.
The NPT request, which my lawyer gave me, do I again upload it there? Because I am afraid that
I do not know. I do
the
not know the answer to that question. What I would suggest is you try to get in touch with the USCIS. It'll take you all day, but you will get through ultimately to a live person. Ask them this question. Personally, very simple. I think what you should do, just the practical solution. What I think you should do is, as soon as you get the receipt of your filing, on the one hand, you should upload it. On the other, you should also mail it along with a copy of the receipt.
I got the receipt number, sir.
Then do both. Then do both. It's what's the problem with that? Just do both. Okay.
So just understanding. I hope this all works out.
Yeah, go ahead and do both. I think you're stuck in a bad situation, but your lawyers seem to be doing all the right things. What else can you do, right?
She did, sir. She's absolutely great person.
Yeah.
She helped me detailing with all the exhibits and all the evidence.
Listen, I'm sorry, I can't stay. I've got to run to another meeting, but I think you're doing the right thing, and as long as you have good legal help, you'll be all right, I think. Okay. Good luck.
Sir, thank you.
You're welcome.
Thank you so much.
You're very welcome. Guys, I'll see you again in 2 weeks. Thursday, not the next one, but the one after. Be well, everyone. Take care.